I welcome on behalf of Center for Peace and Global Studies to our 17th monthly lecture. As usual, our lecture is being live cast on our Facebook page and our YouTube channel. Our Facebook page is www.facebook.com/Global Center Peace, and YouTube channel is youtube.com/@Global Center Peace. Our speaker today is Dr. Muhammad Mushtaq Ahmed, and he will be speaking on Palestine and international law. It's a very important topic of our time. Dr. Mushtaq is an expert in Sharia and law. Currently, he serves as the Secretary to the Chief Justice of Pakistan. He has been a professor of Sharia and law at the Shifa Tamir-e-Millat University. He has served in several institutions in the past and is the author of several books and articles. He has also written on a book on issue of Palestine and international law, which is the topic of today. He holds a PhD in Islamic law and jurisprudence. In today's session, we shall have about 45 minutes of lecture, followed by any questions that you may have. You can ask questions by raising your hands or by writing them in the chat window. Without further ado, I would like to invite Dr. Ahmed to speak to us. Please welcome Dr. Ahmed. Sir, the floor is yours.
Thank you very much. Am I audible?
Yes.
Okay. Bismillah ar-Rahman ar-Rahim. Alhamdulillah, wa salatu wa salamu ala Rasulillah wa ala alihi wa ashabihi wa man wala. First of all, I would like to thank the hosts for inviting me and giving me the opportunity to talk on this very important issue, which is very close to our hearts, and of course, which is a burning issue, and particularly in the when last night we saw that another inhuman and brutal attack has been launched on Palestinian people. But before going into the details of this issue and discussing some of the significant principles and norms of international law relating to this issue, I would like to make a point on how the media is portraying this present phase of the conflict. Generally, we have been seeing that people are talking about it in terms of Israel versus Hamas or Hamas versus Israel, a conflict of that nature. And that, in my humble opinion, undermines many things, and it blurs many significant distinctions, and it also, I would like to say, uh, causes many confusions regarding the nature of the conflict. So, this is not something new. Today, they are calling it as Hamas Israel. Some time ago, they would call it PLO Israel. And a little before that, they would call it Palestine Israel. And before that, it was Arab Israel. And before that, it was Arab Jews or Arab Zionists, things like that. So this nomenclature, this is important. How naming the conflict changes the image of that particular conflict. Of course, the law remains the same, and legally, the nature of the conflict remains the same. But the image in media and the way it is portrayed to common masses, that is very important. So the first thing which I would like to highlight is that this is not a Hamas Israel conflict, and this is not even a PLO Israel conflict. When it was called that way, it was not that way. And even I would not prefer to call it a Palestine Israel conflict or Arab Israel conflict. This is something more than that. And for that, we have to see the history of the conflict and to identify some of the phases. And then we would like to determine the nature of the conflict in the light of the norms of international humanitarian law. And only then we will be able to talk about the relevant applicable laws and principles. So if I started, for example, from the concept of nation state system, which is at the root of the contemporary international legal order. So generally, in academia, they hold that the contemporary notion of nation state, this began with the conclusion of the Treaty of Westphalia in 1648, and that was purely a European phenomenon among the European nations. The treaty was concluded, and they were formally part of the so-called Holy Roman Empire. And then there were conflicts and wars, and finally peace was concluded, and then the so-called nation states came into existence. And for the next 200 years, this nation state system remained confined to European continent only. And for the first time, a semi-European, though non-Christian nation, which was acknowledged certain rights. It was in 1856 when certain rights were acknowledged for the Ottomans in this system. Otherwise, it remained confined to Christian European nations. And even in 1905, when Oppenheim wrote his famous treatise on international law, he explicitly stated that this international law is European and it is Christian. And he said that the United States of America was an extension of the Christian Europe. And he said, furthermore, that as far as other non-European nations are concerned, they have to accept certain conditions, and only then they would be allowed, so to say, entry to this exclusive club. And three conditions which he mentioned there: number one, that they must have reached a certain level of civilization, a threshold of civilization. Number two, that they must be ready to accept the terms and conditions of this exclusive club before they are allowed entry. And number three, that those who are already in the club, they allow their entry. So these three conditions he explicitly mentions in his treatise on international law in the very first edition, 1905, and even in the second edition, which was in 1911. uh, he talks about Ethiopia, which he says was a Christian nation, but it was non European. And he said it was not yet able to enter into this exclusive club because it had not met that threshold of civilization. He was very explicit on this. This was in 1911. And later on, when World War the First was there. Before that, of course, this was the age of colonization. Many European nations, they came out and they colonized people in Asia, Africa, and elsewhere. But in World War the First, they came up with a new system which was called the mandate system, and they divided the uh, various territories into three types of mandates: mandate A, B, and C. And those territories which were formerly part of the Ottoman Empire and which were occupied in World War the First, they were placed in mandate A. And in the Treaty of Versailles, they concluded among themselves that the people of these territories would be given a choice, that they may choose their master. But when Prince Faisal, when he went to Paris and for talks, he was not even heard. So this territory came to the British hands, and it was during the British mandate that settlements of Jews took place. From 1917 to 1948, influx of settlers was there. And of course, we know about the infamous Balfour Declaration. So that was when the seeds were sown of all this discard and mischief and all this bloodshed. So if we have to start it, we have to start it from the signing of the Balfour Declaration 1917. And this conflict should not be considered a Hamas-Israel conflict. If at all we do not go for hundreds of years before that, we at least have to start it from 1917, the Balfour Declaration. So from 1917 to 48, the mandate period, and then in 1948, when the British uh, they had, told the United Nations that they would no longer be able to hold this trust and they would want to leave it. It was much in the same way as they did in India, what a famous writer called a shameful flight. Stanley Wolpert, I'm referring to him. He said that what the British did in 1947 with India, it was a shameful flight, and similar shameful flight was there in this territory, and British, they abandoned this trust. And the United Nations General Assembly came up with the partition plan. And the father of the nation, that is the Pakistani nation, Qaid Azam Muhammad Ali Jinnah, uh, severely criticized it in his letter to the American president. And it is worth mentioning that from 1933 to 1947, there were so many resolutions by the All India Muslim League in favor of Palestine and against the British policy in this territory. Uh, so in 1948, when the so-called State of Israel came into existence, now I would refer to another important international treaty, which is called the Montevideo Convention on the Rights and Duties of States, 1932. This Montevideo Convention defines states, and it mentions four essential ingredients for statehood: that there should be a well defined territory, then there should be some permanent population, and then, of course, government, and fourthly, capacity to enter into relations with other states. Now, interestingly, uh, Israel territory is not well defined, and on almost all sides of its borders, the border remains disputed. Well, there may be some border disputes between various states. uh, uh, some differences may be there on some parts of the borders, but to have disputes across your borders on all sides, this is a peculiar example, and there is no other example as far as I know. Similarly, when it comes to permanent population, well, population will be open in the sense that there will be naturalization and people will come, will take citizenship, and people will go and abandon citizenship. Okay, that's understandable. But to have a law in the form of the law of return, the so-called law of return, which entitles each and every person who is born of a Jewish mother, and even if he is born in the other side of the globe, in any part of the world, to entitle him, to give him the right of settlement and citizenship in this territory. This is again a peculiar law which exists only in Israel, and it exists nowhere else. And interestingly, this law of return allows, for example, a European or an American born person the right to settle in this territory and to acquire citizenship if he is born of a Jewish mother. But those who have been in this territory for thousands of years, for hundreds of years, this law does not give them this right. And even if some of the people who are born here and who are not Jews and who are of Arab origins and who have been given citizenship in Israel, they have been treated differently and distinctly, like second grade citizens. They do not have those rights which these people of Jewish origin have. So, in this sense, if I call it an apartheid state, it will not be wrong. It is absolutely true, and there are many other international documents which record this particular aspect of the Israeli so-called democratic state. So this is the Montevideo Convention. Okay, now another important treaty to which I should refer here is the 1928 Pact of Paris, which initially was concluded between the United States of America and France. And Article 1 of this treaty prohibited war as an instrument of state policy and for settlement of disputes. And international law experts generally agree that this treaty prohibited war. And from this time onward, war territories acquired by the use of force would not be considered as part of the occupying state. So, occupation and annexation would no longer be considered legal means for acquiring title to a territory. Add to this Article 2, sub Article 4 of the UN Charter, which prohibits not only war but also the threat or use of force against the territorial integrity or political independence of other states, or in any other manner inconsistent with the purposes of the United Nations. Uh, Article 2 4 prohibits the use of force, the threat of the use of force. Article 2, sub Article 3 imposes a positive obligation of settlement of disputes peacefully. Article 2, sub Article 7 of the UN Charter prohibits interference in the internal affairs of other states. Uh, in this context, and keeping in view several other provisions, most of the international law experts and most of the states have formed this opinion that the United Nations Charter prohibits or it puts a comprehensive ban on the threat or use of force, and that there are only a few exceptions which are explicitly mentioned in the Charter. One is the collective use of force under the authority of the UN Security Council, Article 43, and the other is self defense when an act of aggression is committed against a state, and this is under Article 51 when there is an ongoing armed attack. Israel perhaps is the only one, or at least it is the first state which denied this, and it explicitly asserted on many forums, including the UN Security Council and the UN General Assembly. It asserted that this ban on the threat or use of force is not comprehensive, and that it is only there when you use force in a way that violates the territorial integrity or political independence of another state, or when you violate the purposes of the UN. Otherwise, this there is no prohibition on the threat or the use of force. This is called the permissive interpretation of this Article 2.4 of the UN Charter. Uh, and it several times used this doctrine. For example, in 1976, it attacked Uganda. In 1981, it attacked Iraq. And there are several other occasions on which Israel came up with this interpretation, the so called permissive interpretation of the prohibition on the use or threat of the use of force under the UN Charter. Okay, next, I will refer to uh, the 1956 Suez Canal crisis, where Israel, along with UK and France, committed aggression and they invaded. But then there was the UN Security Council resolution, which was vetoed, of course. And then there was a resolution in the United Nations General Assembly called the Uniting for Peace resolution. Uniting for Peace resolution was first of all used during the Korean War in 1950, when the Soviet veto uh, paralyzed the UN Security Council and it could not take action against North Korea. So a resolution was passed by the UN General Assembly entitled Uniting for Peace. And as if the UN General Assembly took upon itself the responsibility which initially was uh, on the shoulders of the United Nations Security Council. But because the Security Council was blocked by the veto of the permanent members, so the General Assembly came up with this resolution. Uh, and then using that resolution, the United States of America and others, they formed a coalition and they used force and they intervened in that Korean peninsula and intervened in that war. Similar coalition was expected, or at least hypothetically it was there in 1956, but then because they withdrew their forces it could not materialize. But this was an interesting development in the form of this resolution, the so-called Uniting for Peace resolution. uh, then I should also refer to the international humanitarian law instruments, which are very much relevant to this particular context. Uh, by international humanitarian law, we mean uh, the law of armed conflict. And Islamic law, of course, has a rich history, and detailed rules were laid down in the Holy Quran and the Sunnah of the Prophet sallallahu alaihi wasallam, and we have the role models of the companions of the Prophet, Allah be pleased with them. And then we have detailed expositions of the Muslim jurists for centuries. But when it comes to the modern international legal order, the history of international humanitarian law or the law of armed conflict is not very long. They begin it with the Battle of Solferino in 1859, and they talk about the Swiss trader who was a devout Christian, Henry Duna, who saw many people on the battlefield, wounded, sick, and dead bodies, and nobody was taking care of them. And then he wrote a book in the memory of Solferino, and then he came up with the idea to have an organization for helping the oppressed and the wounded and the sick on the battlefield, and also to have a treaty for this purpose. So in 1863, he formed that committee, which is now called the International Committee of the Red Cross, the ICRC. And in 1864, the first Geneva Convention was signed for amelioration of the sick and wounded on the battlefield. And then there was the St. Petersburg Declaration of 1872, and then the Hague Regulations of 1899 and 1907, and then other Geneva Conventions. And after World War II, in 1949, the four Geneva Conventions were signed, and they have universal acceptance because all member states of the United Nations organization have signed and ratified them. In 1977, two protocols were added to these Geneva Conventions. Now, the first Geneva Convention of 1949 is about wounded and sick combatants on battlefield, and the second is about wounded and sick combatants at sea. The third one is about the prisoners of war, and the fourth one is very much relevant to our discussion here. It is about the protection of civilians during war, and also it is about protection of the people of occupied territories. So the law of occupation is generally found in this fourth Geneva Convention, and it also gives detailed rules for the protection of civilians during armed conflict. And then the two additional protocols of 1977, both of them generally are about the protection of civilians, but Protocol 1 is about international armed conflicts, and Protocol 2 is about non international armed conflicts. And it is also generally agreed upon by the experts of international law that many of these provisions have become uh, or they were already in found in customary international law. So as rules of customary international law, they bind all states, even those who have not signed or ratified any of these treaties. Now, because of the treaty, the Pact of Paris 1928, and because of the law of occupation, it is also a well established norm of international law that occupying forces do not have the title to the occupied territory, and that sooner or later the occupying forces have to vacate that territory. This is a well established norm of international law that occupation does not entitle you to that territory. You have to leave it sooner or later. And because of this, there are so many other implications which are also well known and well accepted and well established in international law. For example, the occupying forces cannot take oath of allegiance from the people of occupied territory, because resistance to occupation is legally an acknowledged right. The people of the occupied territory have the right to resist the occupying forces and to fight against them. And occupation is illegal, and it is a continuation of war. Even if no single bullet is fired, even if no resistance to invasion is found, even if no resistance to occupation is there, still occupation is illegal. Still, the occupying forces have to vacate the territory, even if it is a prolonged occupation, even if it lasts for decades. Still, it is illegal. It does not become legal by the lapse of time. So occupying forces have to vacate their territory, and occupying power cannot change the demography of the occupied territory. And one of the means which Israel has been employing is settlement of people there, bringing them from various parts of the globe and settling them in the occupied territory. And now the same is being repeated uh, in Indian occupied Kashmir. They have also changed the domicile laws there, and they are doing it in much the same way there. So we have these two similar examples: India here and Israel there. Uh, Another important aspect of international law which should be discussed here is the right to self determination. And again, I should talk about the double standards of the Western powers, because it was Woodrow Wilson, the US president, who was considered to be the torchbearer of civilization, and who would talk about right of self determination for all people. But uh, essentially, he was talking about the right of self determination for European white races, and that is why uh, he never applied it to people, say, of Palestine or any other territory. It was specifically for European nations which were occupied during World War I by other European nations. And similarly, when Churchill was talking about the right of self determination during World War II, he also specifically meant European nations. So, this double standard has always been there. And also, the United Nations Charter specifically talks about the right of self determination. And then there are so many resolutions of the United Nations General Assembly on the right to self determination. But then they say that these resolutions of the UN General Assembly, they are not binding even on those states which vote in their favor. And they call it soft law. But this is not the whole truth, because these resolutions can also be considered as evidence of customary rules of international law, and they may be considered as the evidence for that, for the intention of the various states who vote in favor of these resolutions. So there are many resolutions for eradication of colonialism and for vindication of the right to self-determination for all people. And the 1960s decade was particularly called the decade of decolonization, and there were so many new nations which changed the color and the flavor of the United Nations in 1960s and then in 1970s. And that is why we then saw, in the form of the first protocol additional to the four Geneva Conventions of 1949. In this first protocol of 1977, Article 1, Subarticle 3 specifically talks about uh, wars of national liberation. And by virtue of this article, these wars of national liberation, they are considered international armed conflicts. So they are no longer considered to be internal problem of a state. No, occupation is illegal. Occupation of a territory does not give you title to that territory. People of occupied territory have the right to resist and to fight against occupation. And this is an international armed conflict. This is not an internal issue. And that is why people who fight for national liberation, they are also entitled to the combatant status under Article 45 of the Protocol 1. They are entitled to combatant status when they are fighting, and when they are captured by the adversary, they are entitled to the status of prisoner of war. So this was a great development, and which was not acceptable to the United States of America and other Western powers, who, of course, knew that it would be problematic for their blue-eyed child, Israel. Anyhow, these instruments are there, and there is also the very famous Declaration of Principles of International Law, 1970 resolution of the United Nations General Assembly, which, among other principles, mentions the right to self determination and also the right to resist alien and racist occupation and domination, and also acknowledges the right of other people, other nations, to support them. And this support can be in various means and various ways and various forms. Uh, Now, coming to another aspect of this conflict, applying these principles to the conflict in Palestine and other territories, even if one accepts, for the sake of argument, that the territories which were given to the state of Israel in the partition plan by the UN General Assembly in 1948, the fact of the matter is that Israel has occupied so many other territories beyond what was given to it in that partition plan. So, to begin with, at least those territories which were not part of that partition plan are not part of Israel, and they are occupied territories, and they must be acknowledged as such. And officially, this is the position of the United Nations organization, that they are occupied territories. And uh, that is why there is this very famous advisory opinion of the International Court of Justice uh, on the legality or on the legal consequences of the construction of a wall in occupied Palestinian territory, 2003. And as you know, the UN General Assembly asked the International Court of Justice about the consequences of the construction of that wall. This resolution was opposed by Israel and her allies, but by a majority, the resolution was passed, and then the ICJ was asked to give its opinion. The ICJ then took up cognizance of the issue. One of the objections was that this is a political issue which the court should avoid, but the ICJ, by a majority, of course, the Israeli judge was giving his dissent. By a majority, the ICJ decided that this was not a political question, that this was a legal question, and that they were obliged to give answer accordingly. And then the ICJ uh, analyzed in quite detail the various instruments of international law applicable to this issue. It analyzed the issue from the perspective of international humanitarian law, some of which I referred already. And the ICJ also talked about the applicability of international human rights law. Also, it talked about occupation law, and then it also uh, determined the legal consequences of the construction of this wall for Israel, for Palestinian people, for other states, for members of the United Nations organization. So that is a landmark judgment. One would say it was never implemented, but that is an inherent problem in the international legal order. In any case, this judgment is something which should be celebrated and which should be read and which should be taught to students of international law across the globe, because it talks about, it analyzes this conflict from the perspective of international law, and it applies various rules and principles of international law on this particular conflict. Uh, for example, one of the issues today is that of uh, attacks on hospitals and attacks on civilians. And Article 51 of the first additional protocol of 1977 says that reprisals against civilians are prohibited. Attacking civilians is prohibited in the first instance. No one should attack civilians. And even in reprisals, civilians should not be targeted. It is no excuse that one party is attacking the civilians, so the other party is given a license to commit the same. No, this is wrong and that is wrong, and two wrongs do not make one right. So this is also one of the established principles of international law, that civilians must not be targeted. And there are only two exceptions. One, where the civilians lose their protection because they directly participate in hostilities. Now, there is also distinction between direct and indirect participation in hostilities. And it is only when there is direct participation in hostilities that a civilian loses his or her protection under international law, for so long as he or she is directly participating in hostilities. The International Committee of the Red Cross has given its opinion on this issue, and it has used the so-called concept of revolving door, that uh, when a civilian takes up arms and directly participates in hostilities, he loses his protection. But when he lays down arms, he again becomes entitled to that protection which is there for civilians. So as long as they participate in hostilities directly, they can be targeted, not otherwise. This is one. And secondly, when distinction between civilians and combatants is not possible, in that scenario, there must be several precautions which the attacking forces must take before launching the attack. Before launching the attack, all precautions must be taken for sparing civilians in choosing the time of the attack, of course, in choice of weapons and many other things. And from several perspectives, all these precautions which are mentioned in Article 55, 56 of the first protocol, these precautions must be taken. Even then, when certain civilians get targeted unintentionally, this may be tolerated as incidental loss. But the way Israel has been doing it in Gaza and West Bank, it cannot be justified under any of these principles. Uh, so this is a very, of course, uh, serious and uh, gross violation of international law. And it brings me to another aspect of this issue, that certain violations of international humanitarian law are called grave breaches in the Geneva Conventions. In the four Geneva Conventions, in each one of them, we have a list of grave breaches. Now, these grave breaches of international law, its serious violations of Geneva Conventions, they are today called war crimes if they are committed during war. And many of them can be considered crimes against humanity, even when they are committed in peacetime. For crimes against humanity, there need not be a war. Of course, for war crimes, there must be a war, and only then one can talk about war crimes. But for crimes against humanity, war is not an essential ingredient. So, some of these atrocities, which are found in the list of war crimes, they are also found in the list of crimes against humanity. As I said, this is a situation of occupation, a prolonged occupation. And occupation, even if it is prolonged, it is a continuation of war. So they are war crimes as such. And they are also crimes against humanity because they are committed against civilians and unarmed people. So there must also be a mechanism for enforcing international criminal law against these criminals who are committing these crimes, war crimes and crimes against humanity. They must be tried and they must be prosecuted and they must be punished. And there is an international criminal court for this purpose. International Criminal Court has come into existence as a result of the Rome Statute of 1998. It has started working since July the 1st, 2002, when 60 ratifications were there. It has global universal jurisdiction. It can try people and punish them who are accused of and who are proven to have committed war crimes, crimes against humanity, the crime of aggression. Uh, and uh, there are three ways in which a case can initiate in international criminal law. One, when a member state brings a case to the ICC, to the International Criminal Court. This is one. Second, when the United Nations Security Council sends a case against a person to the ICC. And third is when there are so many uh, pieces of evidence uh, on the basis of which the prosecutor of the International Criminal Court considers that there is enough material to prosecute a person. Now, whether a member state will bring a case against an Israeli commander or, say, Netanyahu for these various crimes, it is debatable. Whether the UN Security Council will ever send a case against Netanyahu or any Israeli political or military commander, of course, it seems out of the question. But what me and you can do, what people across the globe can do, they can bombard the office of the prosecutor of the ICC with complaints coupled with evidence, and uh, if there is enough material, the prosecutor will be under an obligation to initiate prosecution. And of course, it takes a lot of time to conclude one case, but this symbolic justice is very important, and this aspect must be uh, explored and used. Uh, Also, there are several countries in different parts of the world where courts have universal jurisdiction on war crimes and similar atrocities. So that avenue should also be explored. And now, at the end of this discussion, I should talk a little about the Organization of Islamic Cooperation, uh, which came into existence because of Palestine and because of the occupation of these territories, particularly Al Quds. Uh, and it is under an obligation to, uh, mm, of course, take action and steps against Israel on uh, on the basis of these various atrocities which it has been committing. There are 57 member states of the Organization of Islamic Cooperation, and they can make a difference, and they can, of course, bring a halt to this invasion and this brutal invasion if they show some seriousness, and they have to think about other possibilities, such as I said, using the International Court of Justice, using the International Criminal Court, using the forum of the UN General Assembly, and even pushing the UN Security Council, using their pressure there, and also their own forum, the OIC. Why the OIC cannot establish its own international criminal court? Why it cannot come up with the collective use of force? If the United Nations can have this concept of collective use of force in chapter 7 of its charter, why the OIC cannot have it? And the United Nations Charter was signed in the aftermath of World War II. A lot has changed since then, and now even those founding members of the United Nations, they are talking about and they are thinking about some other system. And for example, think about FATF, G7, and other organizations which are gradually taking many of the things from the United Nations, and now these things are going to the domain of these other organizations. So OIC members should also think about this way and should envisage some mechanism for the collective use of force for the defense of Al Quds, at least, because it is a common and universal obligation for all Muslims to protect it. And that is why I started my discussion on this issue by negating that this is not a Hamas Israel conflict, this is not a PLO Israel conflict, this is not a Palestine Israel conflict, this is not an Arab Israel conflict. It is a conflict for all Muslims. And even if one can say, and others, if they come and join us in this, it is a conflict for all humanity, because this will affect all of us across the globe. And today, because of technological revolution, we all are connected to each other. So events taking place in one part of the globe directly affect the other parts of the globe. So we all are affected, and we all should feel the responsibility and should come up to stop these atrocities. These are some of my humble suggestions on this issue. I'm not sure if they were useful and beneficial, but if there are some questions, I will be happy to address them. And also, if there are some comments, I will be welcoming them so as to correct myself and to learn more from you. Thank you.
Jazakumullah khair. Many thanks for an informative lecture. We do have one question from Dr. Fakhrul Islam. Could you please unmute yourself?
Yes, Assalamu alaikum.
Walaikum.
And the speech and the presentation by Professor Dr. Mushtaq was very thought-provoking, and it really explained the genesis of the issue in the light of international law. So it proves his speech proves that and the whole civilized world is supporting them. Look at the yesterday's resolution in the General Assembly that almost 72% of the members supported the ceasefire and end to the ongoing conflict. So, I mean, that is something which has been further explained by Dr. Mushtaq. But, the concern is about the current situation and the difficulties faced by the Palestinian in Gaza and the future of this conflict. I mean, these are something which really disturb the Muslim Ummah all over the world. So may I request Dr. Mushtaq Sahab to throw some light on the current situation, how to avert it, and what is the future, strategy and solution of.
Thank you very much, dear sir, for appreciation and also for raising this very important question. In my humble opinion, the current situation, the first thing we all should do in this current situation is that there must be effort for a ceasefire, because unless there is cessation of hostilities, no further action can be taken. And for ceasefire, of course, Israel will never accept that unless it achieves its purposes. So this is not an easy bargain, and this necessitates a concerted effort from OIC members, 57 states. This is a large number, so OIC can play its role effectively. We all have to convince our government, respective governments, to take this matter seriously and use the OIC forum, use the General Assembly forum, use the Security Council forum and other forums, and compel Israel to agree to a ceasefire resolution. Unless that takes place, nothing will improve. And if it is not possible through talks, let me be very blunt. This is not possible unless Israel feels, or unless any other aggressor feels, that it will also face similar consequences, and only then it will come to its senses, and only then it will agree to a ceasefire. So just passing resolutions or just requesting and praying, this will not work unless there is some seriousness shown by the surrounding countries particularly, and other members of the OIC and other members of the United Nations. Unless they take place, I don't think if it is going to stop immediately.
I'll take one question from the chat from Sister Aisha Jadoon. She's saying Israel is imposing collective punishment on the Palestinians. So what is the venue for the accountability, and who dare to compensate the victims, because we can just complain about it?
That's true. And collective punishments is one of the crimes against humanity and one of the war crimes as well. And as I said, the forums are there. One is the International Criminal Court, and of course, there are some countries where war crimes can be. Those who are accused of committing war crimes, they can be prosecuted. uh, Universal jurisdiction is acknowledged for certain courts in certain countries. For ICC, International Criminal Court, I mentioned that there are three means for activating it. One is that a member state brings a case, and the other is the United Nations Security Council sends a case, and third is that the prosecutor initiates a case on the basis of the information and evidence available to him. So that option is available to each one of us. If we have some evidence and if we have some workable information, we should share it with the ICC prosecutor, and then hopefully the ICC prosecutor's office will be compelled to initiate prosecution, even if there is one case against only one of the perpetrators of these crimes. I hope it will give the message to others, and this will bring some change.
Okay. Brother Hassan, could you please unmute yourself?
Assalamu alaikum. Can you hear me? I've been having problems this side. Right.
Yes. Yes,
The
we
two very important issues is that who benefits from this conflict? I mean, Israel or Palestine, there is nothing to benefit, right? So there must be an outside factor that is responsible. there's a bigger picture who's going to benefit. And I mean, we can see this from going on. Even for the United Nations, I mean, what they do is now Palestine becomes a beggar again, because as always, they will start bringing aid and nothing will happen. So the Palestinians are dependent upon that aid. So we can see that submission that they are put into. But the bigger picture is already we could have seen when the Israeli Pharaoh stood before the United Nations and he gave the bigger plan. I mean, that already would have shown to the world their vision and the way they were going to. So it's again looking in the face of power. There's always fear and favor. So yes, you can say there's not going to be any accountability for this generation in front of the world court, because there's the powers that dominate that. So what happens now? Where do we go from here? That is the issue. And I'm talking about the people of the world, because it's not an Israeli or a Muslim issue. It's a humanity. It's about humanitarian. It's how people, children, all killed. And how can the world watch this like it's a movie? And that is what's hurting, because every home has this tragedy. And I think what we've done is that really, we may have lost hope in humanity, but I think with the reversal of the media intifada, if you want to call it, the world is now trying to see the other side of the coin. And maybe that battle might have won, is that we've changed the opinion of a lot of people in the world. Sorry, it's either a comment or something, but it's the feeling after what's happened last night. Thank you so much.
No, I certainly agree, and I can feel the pain, of course, and we all share it, and it is true. And this is I should say that this should be considered positively from one perspective, that there is some light at the end of the tunnel. Uh, what I have been watching on social media, on Twitter and other forums, formerly, whenever Israel would do something, there would be a lot of propaganda and disinformation, and even the world renowned media outlets would not tell the whole truth to the people. But now, because of this technological revolution and because of social media and other forums, many things which formerly were unknown to many people across the globe, they are now universally known, and they have their effect. Of course, there would be misuse of social media as well, and of course there will be disinformation and there will be distortion of facts in one way or the other. But there is a positive change, and which is felt across the globe. We should not despair, and we should think about other possibilities. And perhaps uh, this grip of the fictitious person called state is also weakening with the passage of time, and people across the globe are connecting to each other. And this connectivity, as you rightly said, this is a problem for the whole of humanity. So this common feeling will bring some positive change, inshallah.
Brother Ibrahim, could you please unmute yourself?
Assalamu alaikum wa rahmatullah.
Alaikum assalam.
Thank you very much. May God bless you for this ample and beautiful presentation. Just a question, sir. That have it been the professor is having opportunity to be called by UN to participate in the final peace or resolution between the Israel and Palestinian? What would be a special advice for final resolution and peaceful between them and in general in this world? So this just only my question, please. Is there any advice that he could be able to give and would bring down all this genocide issue? Thank you very much. May God bless you. Assalamu alaikum wa rahmatullah.
Wa alaikum assalam wa rahmatullahi wa barakatuh, brother. I am but a small fry, and I can only give my suggestion, which I have already given. The only way out for all of us, and for Israel and for all, is to abide by the rules of the game, to abide by the law. Rule of law is the way out. The law may not be very much in accordance with our wishes, but at least we have a common ground in the form of these various treaties and conventions and principles and norms and judgments. Let us abide by them. That is all what I can say, and that will bring some positive change once we have these principles and these rules and these conventions and treaties, and we abide by them. Then, uh, if we have problems with the laws, we can change them. But the problem with Israel and her allies is that they do not accept any of these rules when they do not benefit them. That is the problem. So if one could convince them of the benefits of the of abiding by the law, then perhaps we will have a better world to live.
Brother Sayyid Mujtaba Hassan, could you please unmute yourself?
Yeah,
May I
Assalamu
request
alaikum.
sorry, if I may request that if this may be the last question, because I have been called for another meeting. So
Oh,
of course there will be so many other things, but just to
yes, okay.
Yeah, thank you. Assalamu alaikum. Thanks a lot for this uh, very informative presentation about. So about this ICC that you have mentioned, and about that if you have some facts or something that we can present or submit to the ICC as a complaint to take the action. So what kind of the facts, like now in the form of the social media, we have so many things like it's available to across, like it's something like the beyond that what is he looking for, or it's just because everyone is receiving in the different forms, the different the videos or form or something like, which is really heartbreaking. So whether we can use the same stuff to complain, to raise our voices at the ICC platform, that's sufficient,
okay,
or something more evidence are required,
yeah.
because now the TRT, this Turkish media, Al Jazeera, they are really reporting every single thing, and then it's really a kind of they were mentioning that it's similar to the Hiroshima, the bomb which was dropped at the Hiroshima. It has made the similar destruction actually in Gaza. They have made in the last couple of weeks.
Yeah, this is I think a very important question. What I meant uh, was not only information. As we all know, some of the videos, some of the uh, pictures may be doctored, may be tampered with, may not be reliable. Forensic report may be needed for ascertaining their authenticity, etc. When it comes to a court of law, particularly when it comes to a criminal court, the standard of evidence is very harsh and very high, and the threshold is very high, and it is very difficult to prove the crime beyond a reasonable doubt. So a lot of effort is needed for that purpose. Moreover, uh, we have to appreciate and understand the distinction between the atrocities and connecting these atrocities with a particular individual, holding him or her responsible for these atrocities. A causal link has to be established. That, for example, this particular order was issued by this particular commander, and or this particular act was committed by this particular person, because criminal law, as you know, is based on individual responsibility. Individual criminal responsibility is the backbone of criminal law. So for establishing the guilt of a person, we have to establish a causal link and then prove his guilt. So a lot of effort is needed, not just collecting these various clips and other things, but these clips and these news items, etc., they can at least compel the United Nations organization and other organizations to send fact finding commissions to establish facts, to come up with their investigation and inquiry reports. And then those reports may have hints or may have evidence about the connectivity of various persons. And then among those persons, some may be chosen for being prosecuted in international criminal court or other forums. So there is so many things are there, and so many possibilities are there. All we need is to have a concerted effort, and we all should participate in it in various capacities, and there may be some positive results at the end, inshallah.
Jazakumullah khair, Dr. Mushtaq. Many thanks for taking time out from your busy schedule. And we apologize to all those who are still wanting to ask questions. We have raised hands and lots of questions in the chat window. We don't have enough time.
The last point, we may request Dr. Mushtaq to recommend some documents or a book that can be useful for the participants. Some of them are asking about that.
Yeah, if and I may also make an offer, because I also feel that some of the participants may have some very important questions and comments from which I would also love to learn. So if I share my email address with the hosts, with Dr. Ehsan Malik, and then you send your questions on that email address, and I will try to answer them at the earliest, inshallah. And I will also share a few documents and references in English and Arabic and other languages for those who want to understand the legal aspects of this dispute, inshallah.
Jazakumullah khair. Thank you very much for joining. Once again, we'll be meeting again next month. The last Saturday of next month will be our 18th monthly lecture. And the recording of the current lecture is available on our Facebook page, and it will also be available on our YouTube channel. You can please watch it, share with your friends, and we'll meet each other again next month, inshallah. Assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum salam wa rahmatullah.